Have you ever paused to wonder how a nation as vast, diverse, and undeniably complex as India actually governs itself? How are its laws crafted, its leaders chosen, and perhaps most crucially, how are the fundamental rights of its billion-plus citizens protected? It's a monumental undertaking, really.
It truly is an incredible feat of democratic orchestration, you might say. India stands as one of the world's most intricate yet um, remarkably functional democracies.
Yeah, the sheer scale.
The scale, the governance, the delicate balance within its political machinery, it offers a truly fascinating study.
Welcome to the Deep Dive, where we take complex topics and, well, rather than just throwing facts at you, we try to break them down into digestible, often surprising, and always insightful nuggets of knowledge.
And today we're embarking on, I suppose you could call it, an epic deep dive into the very heart of India's political system.
Exactly. Our mission: to unpack the intricate machinery of Indian governance. We're talking everything from the foundational blueprint of its constitution.
Right through to the everyday workings of its legislative bodies, the independent judiciary, and even administration down to the local level.
We'll explore the history, pinpoint the key players, maybe uncover some surprising facts, and highlight those essential nuggets of knowledge that make this incredible system tick.
And to guide you on this, well, pretty extensive journey, we've meticulously gathered a comprehensive stack of sources. We've distilled detailed notes on Indian polity, examined historical documents, and analyzed various parts and landmark amendments of the Constitution.
So the goal isn't to turn you into a constitutional lawyer overnight.
Definitely not, but rather to provide you with a powerful shortcut to being genuinely well-informed about one of the world's largest and I think most vibrant democracies.
All right, let's unpack this. So where do we even begin with the story of India's constitution? It certainly wasn't conceived in a vacuum. There must have been a very specific starting point, right?
Absolutely. The foundational moment, the real kickoff for India's constitutional journey was the Cabinet Mission Plan of 1946.
Okay, 1946. Why that plan specifically?
Well, this plan stands out as uniquely pivotal because, remarkably, it was the only proposal that managed to gain acceptance from both the major players, the Indian National Congress, and the Muslim League.
That's huge, given the tensions.
Exactly. This rare consensus was the critical breakthrough that finally paved the way for the formation of the Constituent Assembly, the body actually entrusted with drafting the future constitution of independent India.
That is quite a feat, securing agreement from both. What made this plan succeed where, so many previous British proposals had failed?
The key distinction lies in the political climate and the aspirations of the Indian leadership at that point. Earlier British offers frequently fell short because they merely proposed dominion status.
And dominion status meant?
For our listeners, dominion status essentially meant India would be self-governing, managing its own internal affairs, but still remain technically part of the British Empire. The British monarch would still be head of state.
Which wasn't enough by then.
Not at all.
Yeah.
This was unacceptable to the Indian National Congress, which by then was fiercely committed to Purna Swaraj, complete and absolute independence, full sovereignty.
Right.
The Cabinet Mission Plan, while not immediately granting full independence, presented a clear pathway to establishing a fully independent Constituent Assembly. That was a significant step towards addressing that core demand for total sovereignty. It offered a framework that implicitly acknowledged India's impending complete break from the empire.
And who were the British architects behind this crucial plan? The ones who came up with it?
The mission was led by three prominent British cabinet members: Pethick Lawrence, who served as the chairman, alongside Stafford Cripps, and A.V. Alexander. These individuals were instrumental in devising the framework for how India's Constituent Assembly would be structured and operate.
So how was this Constituent Assembly actually structured under their plan? How many members and how were they picked, given India's immense diversity?
The plan was quite meticulous, actually. It envisioned a total of 389 seats for the Constituent Assembly.
399.
And these seats were carefully divided to reflect the existing political landscape. The vast majority, 296 seats, were allocated for what was then British India.
Right.
That further broke down to 292 for the governor's provinces and 4 for the chief commissioner provinces. The remaining 93 seats were reserved for the various princely states, which, still held a semi-autonomous status under British paramountcy at that time.
That sounds like a truly complex jigsaw puzzle, making sure everyone had a voice. How did they approach representation within the British provinces, especially for different communities?
It was indeed a delicate balancing act. The allocation within British India was primarily based on population, roughly one seat allotted for every 1 million people.
1 per million. Okay.
And with each British province, these seats were further divided among three principal communities: Muslim, Sikh, and general. This was a deliberate attempt to provide a proportional voice to different religious and demographic groups.
And how were they chosen? Election, nomination?
For the British Indian provinces, members were chosen through indirect elections. They used a system of proportional representation with a single transferable vote.
A complex system.
Very, but it aimed to ensure that even minority groups could secure representation. Now, the representatives from the princely states, in contrast, were to be nominated by the heads of those states, reflecting their unique political arrangement.
So, with the Cabinet Mission Plan accepted, the process of self-governance truly began. Tell us about the formation of the Constituent Assembly itself. What were the critical early milestones and who were the foundational leaders?
Right, so the Constituent Assembly was formally constituted in November 1946 under that Cabinet Mission Plan framework. Its very first sitting took place on December 9, 1946.
But not without challenges, I imagine.
Exactly. It faced an immediate hurdle. The Muslim League, still advocating for a separate nation, boycotted this inaugural session. In that first sitting, following a tradition, Dr. Sachidanand Sinha, being the oldest member, was elected as the temporary chairman.
Ah, the oldest member tradition.
Yes. But just 2 days later, on December 11, 1946, Dr. Rajendra Prasad was elected as the permanent president of the Assembly, a role he would hold with distinction, ably supported by H.C. Mukherjee and V.T. Krishnamachari as vice presidents.
The Assembly was clearly getting down to business very quickly. I know the objective resolution is often seen as the spiritual cornerstone of the Constitution. What was its significance? It sounds profound.
It really was. The objective resolution was a landmark document introduced by Jawaharlal Nehru on December 13, 1946. After intense deliberation, it was adopted by the Assembly on January 22, 1947.
And it wasn't just a statement, right?
Far more than that. It essentially laid down the philosophical foundations, the guiding principles, and the core aspirations for the Constitution. What's truly fascinating is that, in a slightly modified yet recognizable form, it eventually became the preamble of the Constitution.
Wow. So if you read the preamble today,
You're essentially reading Nehru's initial vision for the new India, a bold statement of intent for justice, liberty, equality, and fraternity.
beyond the monumental task of drafting a constitution, there was the immediate pressing need to govern. How did the interim government function during this critical period leading up to independence?
That's a crucial point. The interim government was constituted on September 10, 1946, a vital step in transferring power. It was led by Pandit Jawaharlal Nehru, who served as the vice president of the Viceroy's Executive Council.
And the viceroy was still involved?
Yes, the Viceroy, initially Viscount Wavell, and then famously Lord Mountbatten from February 1947, remained the president of this council. All members of this interim government were prominent Indian leaders drawn from the Viceroy's Executive Council.
So a bridge to independence.
Exactly. This setup was a critical bridge, allowing Indian leaders to gain practical experience in governance and administration while the Constitution was still being drafted. Key portfolios included Sardar Vallabhbhai Patel overseeing home affairs, Rajendra Prasad in charge of agriculture.
And the Muslim League, did they join?
Yes. The Muslim League members joined later, taking on significant roles like Liaquat Ali Khan handling finance. This diverse representation aimed to build a sense of shared responsibility, even before full independence.
So the stage was meticulously set for independence. What was the impact of the Independence Act of 1947, and how did it fundamentally transform the Constituent Assembly itself?
Well, Lord Mountbatten presented his partition plan on June 3, 1947. Despite the immense human cost and heartbreak it caused, it was reluctantly accepted by both the Congress and the Muslim League as the path forward.
A very difficult decision.
Extremely. This pivotal moment led to India being declared an independent and sovereign state on August 15, 1947. Lord Mountbatten then became the first Governor-General of the new Dominion of India.
And the Constituent Assembly's role changed then?
Profoundly. It ceased to be merely a constitution-making body and also became the full-fledged parliament of the Indian Dominion. It had two jobs now. Simultaneously, the centuries-old position of Secretary of State for India, a direct symbol of British rule, was finally abolished. It's worth noting that Clement Attlee was the Prime Minister of England when India finally achieved its independence, marking the culmination of decades of struggle.
That dual role of the Constituent Assembly must have been incredibly challenging, both drafting the foundational law and legislating for a newly independent nation.
Precisely, and it speaks volumes about the capacity of India's leadership at the time. It performed dual functions. As a legislative body handling day-to-day laws, it was chaired by G.V. Mavalankar.
Okay.
Simultaneously, as a constituent body focused solely on drafting the Constitution, it was chaired by Dr. Rajendra Prasad.
Two distinct roles, two chairs.
Exactly. Beyond these, the Assembly performed several other vital national functions. It ratified India's Commonwealth membership in May 1949, adopted the iconic national flag on July 20, 1947, and on January 24, 1950, it officially adopted both the national song and national anthem.
Busy times.
Extremely. On that same day, January 24, 1950, it also elected Dr. Rajendra Prasad as the very first president of India, marking a smooth transition. Its final session was held on that day, bringing to a close a process that spanned 11 sessions over 2 years, 11 months, and 18 days.
Wow, almost 3 years.
An incredible testament to the dedication of its members. And the total expenditure was around 64 lakh rupees back then.
And at the intellectual heart of this immense drafting process was the drafting committee, famously chaired by Dr. B.R. Ambedkar. Can you tell us more about its critical role?
The drafting committee was arguably the most crucial engine behind the Constitution. Set up on August 29, 1947, and indeed, Dr. B.R. Ambedkar, now revered as the father of the Indian Constitution, chaired it.
And who else was on this vital committee?
It included 6 other distinguished legal minds and leaders: N. Gopalaswamy Iyengar, Ali Krishnaswamy Iyer, Kartikeya Munshi, Syed Mohammad Sadullah, N. Madhav Rao, and T.T. Krishnamachari. A formidable team.
I imagine they worked tirelessly.
Absolutely. They took 141 days just to prepare its initial draft, meticulously debating every clause to ensure a comprehensive and robust document for this new nation.
So after all that intensive drafting, when was the Constitution finally adopted? And perhaps more importantly, when did it come into full force, making India a complete republic?
The Constitution was formally adopted on November 26, 1949, and this date, fittingly, is now celebrated as Constitution Day since 2015.
And did everything start immediately on that day?
Not quite everything. On November 26th, some crucial provisions, primarily those related to citizenship, elections, and the provisional parliament, specifically Articles 5 through 9, immediately came into force.
Okay, key operational bits.
Right. But the full enforcement of the Constitution, truly marking India's transition into a complete and sovereign republic, happened on January 26, 1950.
Republic Day. Why that specific date?
It was deliberately chosen because it held deep symbolic significance for the independence movement. Purna Swaraj Day, the day for complete independence, had first been celebrated on January 26 back in 1930. So it was a very meaningful date.
Ah, connecting back to the freedom struggle.
Precisely. And the original Constitution, as adopted and enforced, was a sprawling, comprehensive document. A preamble, 395 articles, and 8 schedules. A testament to its ambition and scope. It's often remarked that India's Constitution is a brilliant blend, drawing inspiration from various countries around the world. But it's clearly not just a copy-paste job, is it? It adapted these influences to its unique context.
Not at all. It's a testament to the foresight and wisdom of its framers. India's constitution is a masterful synthesis. Its architects meticulously selected what they saw as the most effective features from different major countries,
Right.
adapting them intelligently to India's unique social, political, and historical context, while simultaneously developing entirely original characteristics. It truly stands as a unique and, importantly, evolving document. Let's delve into some of those key international influences. Which foundational documents or constitutions left their imprint on India's blueprint? Where did they get the structural bits?
A significant portion, particularly the structural and administrative backbone, came directly from the Government of India Act of 1935.
Ah, the British legislation itself?
Yes. Though colonial in origin, it provided the practical framework for much of India's governance. It influenced aspects like the federal scheme, the office of governor, the structure of the judiciary, the establishment of public service commissions, emergency provisions, and a myriad of administrative details. It was a ready-made scaffold, you might say, that the framers found useful.
And what about the direct influence of the British Constitution itself? Given the long colonial history, it must have had a profound impact on the political structure, right?
Absolutely. From the British Constitution, India largely borrowed its fundamental political framework. This included the parliamentary system, the very heart of India's democracy.
The Westminster model.
Exactly, the Westminster model adapted.
Yeah.
Also, the vital concept of the rule of law, the legislative procedure, and the idea of single citizenship. We also see the influence of the cabinet system, the use of prerogative writs like habeas corpus parliamentary privileges, bicameralism in Parliament, and the independent office of the Comptroller and Auditor General, the CAG.
So, while the structural part came from the 1935 Act, the core political framework leaned heavily on the British model. What about the influence of the United States? The idea of fundamental rights, for instance, seems distinctly American.
You're spot on. The U.S. Constitution was a profound source for key democratic ideals that safeguard individual liberties. It inspired the fundamental rights that form the bedrock of individual freedoms in India.
A real shield for citizens.
Precisely. Also, the crucial concept of the independence of the judiciary and the powerful principle of judicial review, which allows courts to check the constitutionality of laws.
That's a big one.
Huge. Even the detailed procedures for the impeachment of the president, the removal process for Supreme Court and High Court judges, and the very post of the vice president drew heavily from the American model. And notably, the preamble of the Indian Constitution, with its emphasis on liberty and justice, also draws significant philosophical inspiration from the American one.
That's quite a list already, highlighting a true blend of systems. Any other major influences? I recall hearing about the directive principles of state policy, which are quite unique to India. Where did those come from?
The DPSPs. Yes, the Irish Constitution was the primary inspiration for the directive principles of state policy. These are, as you know, non-justiciable guidelines for the state, aiming to promote social and economic welfare, a concept quite distinctive at the time.
And Ireland influenced other things, too.
Yes, the Irish model also influenced the method of election of the president and the nomination process for members to the Rajya Sabha, India's upper house of parliament.
And what about the idea of a strong federal structure, where the central government holds significant power despite the existence of states? Where did that concept originate?
That strong federal model, particularly one with a powerful central government, was largely adopted from the Canadian Constitution.
Okay, Canada. Like what specifically?
This included crucial concepts like vesting of residuary powers not specifically listed anywhere else in the center. Also, the appointment of state governors by the center and the advisory jurisdiction of the Supreme Court, allowing the president to seek the Supreme Court's opinion on legal matters. These provisions aim to ensure a cohesive and strong union, seen as vital for a country as diverse as India.
Fascinating how they drew from so many different blueprints. Any other unique contributions from other countries?
Absolutely. The Australian Constitution contributed the idea of the concurrent list.
Where both center and states can make laws.
Exactly, allowing shared governance. It also influenced the concept of a joint sitting of the two houses of parliament to resolve legislative deadlocks, a useful mechanism. From the Weimar Constitution of Germany, India adopted the provisions for the suspension of fundamental rights during an emergency, though this was later modified significantly.
Right.
The Constitution of the former USSR influenced the inclusion of fundamental duties, defining citizens' responsibilities, and the ideals of justice, social, economic, and political, enshrined in the preamble.
And France. Liberty, equality, fraternity.
Precisely. The French Constitution provided those lofty ideals of republic, liberty, equality, and fraternity, foundational to India's democratic ethos and prominent in the preamble. The South African Constitution was the source for the procedure for amendment of the Constitution and the method for the election of members of Rajya Sabha. Finally, from the Japanese Constitution, India adopted the concept of procedure established by law, emphasizing due process.
Wow. A true global tapestry woven into one document.
Indeed, a remarkable synthesis.
Now that we've journeyed through the origins, let's talk about the preamble. It's often beautifully described as the soul or identity card of the Constitution. What makes this short document so profoundly significant?
The preamble truly serves as the philosophical essence of the Constitution. It encapsulates its aims, aspirations, and the core values it seeks to uphold. N.A. Palkhivala, a renowned constitutional expert, famously called it the identity card of our Constitution.
Right, I've heard that.
While K.M. Munshi referred to it as the horoscope of the Constitution. It's essentially India's foundational promise to itself and its citizens, summarizing what the nation stands for and what it endeavors to achieve.
What are the key elements embedded within this vital declaration? What does it actually say?
It essentially has four critical components. First, it identifies the source of authority. We, the people of India, boldly declaring that ultimate power flows directly from its citizens. popular sovereignty.
Very powerful opening.
Indeed. Second, it defines the nature of the Indian state. Sovereign, socialist, secular, democratic republic. Sovereign meaning independent, republic meaning an elected head of state, not a monarch.
We'll come back to socialist and secular.
Yes. Third, it outlines the objectives. Justice, social, economic, political, liberty of thought, expression, belief, faith, worship, equality of status and opportunity, and to promote fraternity, assuring individual dignity and national unity integrity.
A comprehensive vision.
And finally, it states the date of adoption, November 26, 1949, the day the Constituent Assembly enacted it.
You mentioned socialist and secular. I recall those weren't in the original preamble. When were they added and what was the context?
You're absolutely right. The words socialist, secular, and also integrity were not part of the original preamble. They were added later through the 42nd Constitutional Amendment Act of 1976.
Ah, the 42nd Amendment, the mini-constitution.
Exactly. This was during the emergency period, a politically charged time, and this amendment made extensive changes, including adding these words to the preamble to reflect the then government's ideological orientation.
What about the preamble's legal standing? Is it directly enforceable by courts like other parts of the Constitution? Can someone sue based only on the preamble?
Interestingly, no. The preamble itself is non-justiciable, meaning it cannot be directly enforced by the courts in isolation. However, its legal status and interpretative value have been the subject of significant judicial debate.
How so?
Well, initially, in the Burabari Union case, 1960, the Supreme Court held that the preamble is not a part of the Constitution. They saw it more as a key to understanding the framers' minds.
Okay, so just a guide, not part of the actual legal text.
That was the initial view. But that position famously changed later, didn't it?
Dramatically. And this led to one of the most significant judgments in Indian constitutional history. In the landmark Kesavananda Bharati case, 1973, the Supreme Court famously overruled its earlier decision in Burabari. This is the big one.
Absolutely. It unequivocally declared that the preamble is indeed a fundamental part of the Constitution and can be amended. However,
There's always a however with Kesavananda Bharati.
precisely, it introduced a crucial revolutionary caveat. While it can be amended, its basic structure cannot be destroyed or altered. This case laid the immutable foundation for the basic structure doctrine, protecting the fundamental identity of the Constitution.
And this stance has held.
Yes. It was further reaffirmed and solidified in the LIC of India case, 1995, where the Supreme Court once again held that the preamble is an integral part of the Constitution. So, while it's not directly enforceable on its own, it serves as an indispensable guiding light for interpreting the entire Constitution.
From the guiding principles of the preamble, let's move to something much more concrete for every individual. Fundamental rights. These are often called the Magna Carta of India. What defines these crucial safeguards?
Fundamental rights, found in Part 3 of the Constitution, Articles 1235, are indeed the bedrock of individual liberty in India. They are justiciable.
Meaning you can go to court.
Exactly. Enforceable by the courts. Any violation can be challenged directly in the Supreme Court or high courts. They were specifically borrowed from the USA, reflecting a strong commitment to individual freedoms against state overreach.
But they're not absolute, right? There are limits.
Correct. They are not absolute but qualified. This means they can be subjected to reasonable restrictions imposed by the state for things like public order, morality, or national security. It's a balancing act.
And during emergencies.
Crucially, they can be suspended during a national emergency, but with a vital exception. The rights guaranteed by Articles 20 and 21 protection against arbitrary conviction and deprivation of life and personal liberty can never be suspended. That ensures a minimum core of protection, even in crisis.
That sounds like a powerful shield for the individual. Before we dive into the specific rights, how does the Constitution define state when it talks about fundamental rights? This seems important for understanding who is bound by these rights.
That's a great point. Article 12 defines state very broadly. It includes the government and parliament of India, the government and legislature of each state, all local authorities like municipalities and panchayats, and even other authorities like statutory corporations or government companies. Basically, any entity acting as an arm of the government.
So it covers a lot of ground.
It does. This wide definition ensures that a vast range of governmental and public entities are bound by and must respect these fundamental rights.
And what happens if a law is created that is inconsistent with a fundamental right? Does it just become void?
Precisely. That's addressed by Article 13. It declares that all laws, whether made before or after the Constitution, that are inconsistent with or take away fundamental rights shall, to the extent of that inconsistency, be void. It's a crucial check on legislative power.
But not for constitutional amendments themselves.
That's the important clarification, yes. This voiding principle does not apply to constitutional amendments made under Article 368, a distinction firmly established by landmark cases, especially Kesavan of Bharati.
How many fundamental rights did India start with, and what's the current number? I know the right to property underwent a significant change.
Originally, the Constitution provided for 7 fundamental rights. You're absolutely right about the right to property, which was Article 31.
Yeah.
It was a significant right that underwent a profound transformation.
It was removed.
Yes, it was deleted from the list of fundamental rights by the 44th Constitutional Amendment Act in 1978. It was then reclassified, becoming a mere legal right under Article 300A in Part 12. So at present, we have 6 core fundamental rights.
Let's briefly walk through these 6, starting with the right to equality, foundational stuff.
Indeed. The right to equality, Articles 14, 18, is foundational. Article 14 guarantees both equality before law, the British idea, no one's above the law, and equal protection of laws, the American idea, equal treatment among equals, allowing reasonable classification.
And Article 15.
Article 15 prohibits discrimination on specific grounds like religion, race, caste, sex, or place of birth, particularly regarding access to public places, shops, wells, roads, etc.
Then we have the right to freedom, which sounds incredibly comprehensive. What's included here?
It is extensive. The right to freedom, Articles 1922. Article 19 is a bundle of 6 core freedoms available only to citizens. Freedom of speech and expression, assembly, association, movement, residence, and occupation. Each, however, comes with reasonable restrictions.
It's a balancing act again.
Always. Then Article 20 provides protection in respect of conviction for offenses, things like no double jeopardy, no self-incrimination. Article 21 is immensely powerful, protection of life and personal liberty.
And the courts have interpreted this very broadly, haven't they?
Hugely. The Supreme Court has read into Article 21 a host of implicit rights: the right to privacy, right to free education up to 14 years, speedy trial, information, even the right to sleep, sustainable development, and the right to marry someone of one's choice, dying with dignity.
Oh.
It's constantly evolving.
And wasn't education specifically added?
Yes, Article 21A, mandating the right to elementary education for children aged 6-14 years, was explicitly inserted by the 86th Constitutional Amendment Act in 2002. And Article 22 offers protection against arrest and detention, distinguishing between punitive and preventive detention.
Okay. Then protection from exploitation.
That's covered by the right against exploitation. Articles 23, 24. Article 23 prohibits traffic in human beings and forced labor like bigar. Article 24 specifically prohibits employing children under 14 in factories, mines, or other hazardous jobs. Crucial child protection.
Freedom of religion is, of course, a cornerstone of India's secular identity. Articles 25 to 28.
Absolutely. The right to freedom of religion, Articles 25 to 28, ensures freedom of conscience, the right to freely profess, practice, and propagate religion. It also covers freedom to manage religious affairs, freedom from paying taxes for promoting any particular religion, and freedom from attending religious instruction in certain educational institutions. It underpins India's secular fabric.
Beyond religious freedom, there are also cultural and educational rights, vital for diversity.
Yes, the cultural and educational rights, Articles 29-30, are vital. Article 29 protects the distinct language, script, and culture of minorities. Article 30 grants minorities the significant right to establish and administer their own educational institutions, allowing them to preserve and promote their culture and identity.
And finally, what many consider the most critical right, the right to constitutional remedies, Article 32.
This is perhaps the most significant, and for good reason. Article 32 is what makes all other fundamental rights meaningful and enforceable. Dr. B.R. Ambedkar famously called it the heart and soul of the Constitution.
Why?
Because it empowers the Supreme Court, and Article 226 empowers high courts to issue various writs for the enforcement of fundamental rights. It makes the Supreme Court the ultimate guarantor and guardian of these liberties. Without this right, the others might just be, well, promises on paper.
You mentioned writs. These are powerful tools of justice, aren't they? Can you explain what each of them does in plain language?
Absolutely. Think of them as the specific orders the courts can issue. There are 5 main types. First, habeas corpus, which literally means to have the body of.
Produce the person.
Exactly. The court commands the detaining authority.
Right.
Bring the detained person before us so we can check if the detention is legal. It's a powerful weapon against unlawful detention.
Okay, next.
Second, mandamus, meaning we command. This is issued to a public official or authority, essentially ordering them to perform their public duty, which they have failed or refused to do. It ensures accountability.
Got it. Third.
Third, prohibition, meaning to forbid. Issued by a higher court to a lower court or tribunal to prevent it from exceeding its jurisdiction or acting unlawfully while the case is still pending. It stops an illegal action before it's completed, directs inactivity.
So it stops things mid-process. What about after a decision?
That's where certiorari comes in, meaning to be certified or to be informed. This is issued by a higher court to a lower court or tribunal after it is given a decision, to quash that decision if it's found to be illegal, or to transfer the case to itself. Prohibition prevents, certiorari cures, or corrects after the fact.
Okay, clear distinction. And the last one.
Finally, quo warranto, which means by what authority or warrant. This writ inquires into the legality of a person's claim to hold a public office. It asks, by what authority are you holding this position? It prevents someone from wrongfully usurping a public office.
Is the writ jurisdiction identical for the Supreme Court and the High Courts, or are there differences? You mentioned Article 32 and 226.
That's an excellent question and a key distinction. The High Court's writ jurisdiction under Article 226 is actually wider than the Supreme Court's under Article 32.
Wider? How so?
While the Supreme Court can only issue writs for the enforcement of fundamental rights, high courts can issue them not only for fundamental rights, but also for any other purpose, which includes the enforcement of ordinary legal rights. This gives high courts a broader scope.
So you could go to a high court for a non-fundamental right issue using a writ?
Potentially, yes. Also, the Supreme Court cannot refuse to exercise its writ jurisdiction, Article 32 being a fundamental right itself, whereas a high court may refuse to exercise its writ jurisdiction under Article 226, as it's discretionary to some extent.
Who can actually avail themselves of these fundamental rights? Are they for all persons residing in India or only citizens?
It varies. Some rights, specifically Articles 15, 16, 19, 29, and 30, are available only to citizens of India. Think freedom of speech, Art 19, or protection against discrimination in public employment, Art 16.
Okay, citizen-specific.
But a significant number, including Article 14, equality, and Articles 20 through 28, life, liberty, exploitation, and religion, are available to both citizens and foreigners residing in India, with the specific exception of enemy aliens. This reflects a commitment to universal human rights principles.
What about Parliament's power to restrict these rights? Can they just be legislated away arbitrarily?
No, not arbitrarily. The Constitution provides specific, controlled avenues for restriction, usually for reasons of national security, public order, or discipline in specific services. Article 33 allows Parliament to restrict or even abrogate fundamental rights for members of the armed forces, paramilitary forces, police, and intelligence agencies to ensure discipline.
Right. Necessary for those services.
Article 34 imposes restrictions when martial law is in force in an area. And Article 35 empowers Parliament, and only Parliament, not state legislatures, to make laws for prescribing punishment for acts declared offenses under fundamental rights, like untouchability, and for implementing certain rights effectively.
Moving from enforceable rights, let's explore the directive principles of state policy. DPSP, found in Part 4, Articles 36 to 51. Dr. B.R. Ambedkar called them a novel feature. What exactly are they?
The DPSPs are indeed a unique feature. Think of them as the instrument of instructions from the old Government of India Act of 1935, but adapted for an independent India. They are guidelines or principles given to the state, both union and state governments, to keep in mind while formulating policies and enacting laws.
But they're different from fundamental rights because...
The crucial difference is that DPSPs are non-justiciable. You cannot go to court to enforce them directly. They embody the concept of a welfare state, outlining the social and economic goals the state should strive towards, like ensuring adequate livelihood, fair wages, reducing inequality. They're aspirational.
So they're more like guidelines or perhaps a moral compass for governance rather than direct legal obligations.
Precisely. Granville Austin famously called the DPSP, along with the fundamental rights, the conscience of the Constitution. While non-justiciable, they aren't irrelevant. The Supreme Court, especially in the Minerva Mills case, 1980, emphasized that harmony and balance between fundamental rights and directive principles are an essential feature of the basic structure.
Meaning,
any law made to implement a DPSP must still be reasonable and not arbitrarily violate fundamental rights like equality, Article 14, or certain freedoms, Article 19. They represent the socioeconomic vision the state should aim for, but within the framework of fundamental liberties.
How are these principles broadly categorized to help us understand their scope? They cover a lot.
They can be broadly classified into three categories, though the Constitution doesn't formally do this. First, socialistic principles, aiming for social and economic justice. A key example is Article 39, which talks about adequate livelihood, equitable resource distribution, preventing wealth concentration, equal pay for equal work, and protecting workers' and children's health. Also, Article 39A, added later, for equal justice and free legal aid.
That sounds like a comprehensive vision for social welfare. What about the Gandhian principles reflecting Mahatma Gandhi's influence?
Yes, the second category is the Gandhian principles, directly reflecting Gandhi's ideology. These include Article 40, directing the state to organize village panchayats, a cornerstone of his vision, later constitutionalized. Article 43 promotes cottage industries. Article 47 aims to prohibit intoxicating drinks and drugs, and Article 48 prohibits the slaughter of cows and calves.
And the third category, the liberal intellectual principles, what falls under that?
This category reflects more modern liberal thought. A prominent example is Article 44, directing the state towards a uniform civil code. Article 45, as amended, deals with early childhood care and education up to 6 years. Article 48 talks about organizing agriculture and animal husbandry on modern lines. Article 48A deals with protecting the environment and wildlife. Article 50 mandates separating the judiciary from the executive, and Article 51 promotes international peace and security.
So these principles have also evolved over time through amendments, just like other parts of the Constitution. Can you highlight how some key DPSPs have been added or modified?
Indeed. The 42nd Amendment, 1976, was significant here too, adding Article 39A, free legal aid, 43A, workers' participation in management, and 48A, environment. The 44th Amendment, 1978, added Article 38.2 to explicitly minimize inequalities. The 86th Amendment, 2002, fundamentally changed Article 45 regarding education, shifting the focus to early childhood care after making elementary education a fundamental right under 21A. And the 97th Amendment, 2011, added Article 43B, promoting cooperative societies. So they definitely reflect changing priorities.
Now let's turn to fundamental duties, outlined in Part IVA, Article 51A. When and why were these added, as they weren't part of the original Constitution?
Right. Fundamental duties were added by the 42nd Amendment Act of 1976, based on recommendations from the Swaran Singh Committee. The idea was basically to remind citizens that rights come with responsibilities. Exactly. While citizens enjoy rights, they also have duties toward the nation, society, and fellow citizens. This concept was inspired partly by the Japanese model, emphasizing that rights and duties are inseparable, fostering civic responsibility.
How many duties were initially added, and has that number changed since then?
Initially, 10 duties were added. Things like respecting the Constitution and its ideals, cherishing the noble ideals of the freedom struggle, upholding sovereignty, defending the country, promoting harmony, protecting the environment, developing scientific temper, safeguarding public property, etc.
And the 11th?
A crucial 11th duty was added later by the 86th Amendment Act of 2002, the same one dealing with education. This is Article 51AK. It makes it the duty of every parent or guardian to provide opportunities for education to their child or ward between the ages of 6 and 14 years. This links directly to the fundamental right to education.
We've now laid out the constitutional blueprint and the core principles of rights and duties. Let's shift our focus to the Union Executive, starting with the highest office, the President of India. What's their fundamental role and position in the Indian state?
The President of India, covered in Articles 5278, is the nominal executive or the de jure head of the Republic. All executive actions of the government are formally taken in their name.
So, the symbolic head.
Symbolic, but constitutionally significant. The President is the first citizen of India, occupies the highest position under the warrant of precedence, symbolizes national unity, and is the supreme commander of the armed forces.
But the real power lies elsewhere.
In practice, yes. The President exercises power on the aid and advice of the Council of Ministers, headed by the Prime Minister. And crucially, accepting this advice became constitutionally obligatory after the 42nd and 44th Amendments, really cementing India's parliamentary system where the elected government holds the real executive power.
So, the President is primarily a symbolic head. How exactly is this figure elected in India? It's not a direct popular vote like in some other democracies, is it?
No, it's an indirect election, carefully designed for federal balance. The President is elected by an electoral college, detailed in Articles 54 and 55.
Who's in this electoral college?
It consists of 3 groups of elected members of both houses of Parliament, Lok Sabha and Rajya Sabha, elected members of the state legislative assemblies, Vidhan Sabhas, and, importantly, elected members of the legislative assemblies of the union territories of Delhi and Pucheri. This ensures the president represents both the union and the states.
And what's the complex election method for this electoral college? It sounds like it goes beyond a simple majority.
It does. It uses a system of proportional representation by means of a single transferable vote, and voting is by secret ballot.
Proportional representation, single transferable vote. Sounds complicated.
It aims for fairness. The value of each legislator's vote is calculated to ensure proportionality between states and parity between the states as a whole and the union. For an MLA, the value depends on the state's population divided by the number of elected MLAs, scaled down. For MP, the total value of all MLA votes is divided by the total number of elected MPs. A candidate needs to secure a specific quota of votes to win, ensuring broad support. It's quite a mathematical process.
How long does a president serve, and can they be reelected for multiple terms?
According to Articles 56 and 57, the president holds office for a 5-year term. Unlike, say, the U.S. president, the Indian president is eligible for re-election for any number of times. There is no term limit.
What are the basic qualifications to become president?
To be eligible, a person must be a citizen of India, be at least 35 years old, and be qualified for election as a member of the Lok Sabha. They also can't hold any office of profit.
And who administers the oath of office to the president?
The oath, under Article 60, is administered by the Chief Justice of India, or, in the CGI's accents, the senior-most judge of the Supreme Court available. This underscores the judiciary's role.
How can a president be removed from office before their term ends? I understand it's an incredibly stringent and rare process. Impeachment.
Exactly, impeachment, outlined in Article 61. The president can only be removed for violation of the Constitution. It's a quasi-judicial procedure, very difficult.
How does it work?
A resolution for impeachment can start in either house. It needs signatures from at least 1/4 of that house's members, and 14 days' notice must be given to the president. Then it needs to pass by a special majority, 2/3 of the total membership in both houses.
2/3 of the total strength, not just present and voting.
Correct. Total membership. A very high bar. If both houses pass it, the president stands removed. To date, no Indian president has ever been impeached.
What happens if the president's office becomes vacant due to death, resignation, or removal? Is there an immediate plan for succession?
Yes, Article 62 covers this. An election to fill the vacancy must happen as soon as possible, definitely within 6 months. In the interim, the vice president acts as president.
And if the VP isn't available?
Then the Chief Justice of India acts as president. If the CJI is also unavailable, the senior-most judge of the Supreme Court steps in. The acting president can serve for a maximum of 6 months, by which time a new president must be elected. Ensures continuity.
Beyond these constitutional roles and how they're appointed, what are the actual powers the president wields? Let's start with their legislative powers.
They have significant legislative roles. The president summons and prorogues parliament sessions and can dissolve the Lok Sabha, usually on ministerial advice. They inaugurate parliament after elections and at the start of each year's first session, outlining the government's agenda.
And bills.
Crucially, all bills passed by parliament become law only after the president's assent. They can return non-money, non-constitutional amendment bills for reconsideration once. If parliament passes it again, the president must assent.
What about the pocket veto?
Yes. Since there's no time limit for assent in the Constitution, the president can technically just sit on a bill indefinitely without taking action. That's the pocket veto. Gianni Zail Singh famously used it on the Indian Post Office Bill in 1986. Also, under Article 123, the president can promulgate ordinances when Parliament isn't in session, which have the force of law temporarily.
And their executive powers. They appoint a lot of key figures across the government, don't they?
Yes, extensive executive powers. Appoints the Prime Minister and other ministers on the PM's advice. Appoints governors, CJI, SCHC judges, the Attorney General, the CAG, Chief Election Commissioner and ECs, UPSC chairman members, ambassadors, a huge list. And as mentioned, Supreme Commander of the Armed Forces.
What about their financial powers?
Money bills need the president's prior recommendation before introduction in Lok Sabha. The president causes the annual budget to be laid before Parliament. They also appoint the Finance Commission every 5 years to recommend revenue distribution between the union and states.
And their judicial powers, appointments and pardons.
Yes. Appoints the CJI and other judges on CJI collegium advice, can only dismiss judges if Parliament passes a removal resolution. And then there's the pardoning power under Article 72.
How extensive is that?
Very. It includes Pardon, complete forgiveness. Reprieve, temporary stay, especially death sentence. Commutation, lighter punishment. Respite, lesser sentence on special grounds like pregnancy. And remission, reducing sentence duration. Crucially, unlike a governor, the president can pardon death sentences and sentences by court-martial.
Finally, what about their diplomatic and military roles beyond just being the supreme commander?
All international treaties and agreements are negotiated and concluded in the president's name, giving them the formal diplomatic role. Militarily, the president declares war or concludes peace, but this is always subject to Parliament's approval, maintaining democratic control.
While the president is the head of state and the symbolic executive, the real executive power, the everyday governance, lies elsewhere. Let's talk about the vice president, prime minister, and the council of ministers. What's the vice president's primary role in this structure?
The vice president, covered in Article 6370, has two main functions. Primarily, as per Article 64, they are the ex officio chairman of the Rajya Sabha, presiding over the upper house.
Like the speaker in the Lok Sabha.
Similar functions, yes. Second, they act as president during vacancies, death, resignation, removal, or inability for a maximum of 6 months until a new president is elected. While they act as president, the deputy chairman handles the Rajya Sabha chair.
How is the vice president elected, and what's their term? Is their election process similar to the president's?
The election process is slightly different. The VP is elected by an electoral college consisting of members both elected and nominated from both houses of parliament. State MLAs are not involved.
Only parliamentarians.
Yes. The method is also proportional representation by single transferable vote, secret ballot. They hold office for 5 years.
And what about their removal? Is it as complex and stringent as the president's impeachment process?
No, it's simpler. The VP can be removed by a resolution of the Rajya Sabha passed by an effective majority of all then members, which must then be agreed to by a simple majority in the Lok Sabha. 14 days' notice is needed, but the Constitution doesn't list specific grounds for removal, unlike the president's violation of the Constitution.
Now to the undisputed power center of the executive, the prime minister and the council of ministers. The PM is truly the real executive, isn't that right?
Yes, absolutely.
Yeah.
In India's parliamentary system, the PM is the real executive, the de facto authority, head of government. Appointed by the president, usually the leader of the majority party or coalition in the Lok Sabha.
And the council of ministers?
Other ministers are appointed by the president on the PM's advice. They form the government. A fundamental principle is their collective responsibility to the Lok Sabha. They swim or sink together.
Has there been any restriction placed on the size of the council of ministers over time? It used to be quite large, didn't it?
Yes, that's a significant point. The 91st Constitutional Amendment Act of 2003 introduced a cap. The total number of ministers, including the PM or CM in states, cannot exceed 15% of the total strength of the Lok Sabha or state assembly.
Why was that done?
To curb the practice of having huge jumbo ministries, often seen as politically motivated and inefficient. This amendment also stated that anyone disqualified for defection is also disqualified from being a minister.
Who administers their oath? And what happens if a minister isn't a member of parliament when appointed? Can that happen?
Yes, it can happen. The president administers the oath of office in secrecy. Ministers hold office during the president's pleasure, effectively the PM's confidence. If someone who isn't an MP is appointed minister, they have 6 consecutive months to get elected to either house. If they don't, they cease to be a minister. Ensures accountability to the legislature.
What about the Attorney General's rights in Parliament? Can they participate in debates without being a voting member?
Yes, precisely. The Attorney General, along with ministers, has the right to speak and take part in proceedings of either House, joint sittings, and committees they might be members of. Article 88 allows the government's chief lawyer to explain legal aspects, but crucially, they don't have the right to vote.
Now let's turn to the beating heart of India's democracy, the Parliament. Article 79 sets out its constitution. How is it structured, and what model does it follow?
India's Parliament is the supreme legislative body based on the Westminster model from the UK. It comprises 3 parts: the President, the Lok Sabha, lower house, and the Rajya Sabha, upper house. No bill becomes law without passing both houses and getting presidential assent. The Hindi names Lok Sabha and Rajya Sabha were adopted in 1954.
Let's start with the Lok Sabha, often fittingly called the House of the People. What's its fundamental nature and composition?
It's the lower house, the first chamber, directly elected by the people through universal adult franchise. It's not a continuing chamber. Its normal term is 5 years, unless dissolved earlier.
At its size.
Maximum strength is 550 members. 530 from states, 20 from UTs. Currently, it's 543 members. 524 states, 19 UTs.
I recall there used to be a provision for Anglo-Indian nomination. Is that still in place?
Good memory. No, that's gone. Originally, Article 331 allowed the president to nominate up to 2 Anglo-Indians if they felt the community wasn't adequately represented. But the 104th Amendment Act of 2019 discontinued this.
When did the Lok Sabha first meet?
First sitting was April 17, 1952. First meeting, May 13, 1952. G.V. Mavalankar was the first speaker, and Mira Kumar the first female speaker.
What makes the Lok Sabha particularly powerful, especially regarding financial matters and government accountability?
Several things. Crucially, money bills and most financial bills can only originate in the Lok Sabha, giving it control over finances. The Rajya Sabha only has recommendatory power over money bills. The Lok Sabha has the final say.
And accountability.
The Council of Ministers is collectively responsible only to the Lok Sabha. So, confidence and no confidence motions happen here, determining the government's survival. The Lok Sabha can also disapprove a national emergency continuance, even if Rajya Sabha disagrees.
Can the tenure of the Lok Sabha be extended beyond its usual 5 years?
Yes, but only during a national emergency, Art. 352. Parliament can extend its life by 1 year at a time, but fresh elections must happen within 6 months after the emergency ends.
What are the basic qualifications required to become a member of the Lok Sabha, an MP?
Must be a citizen of India, at least 25 years old, and a registered voter somewhere in India. Pretty straightforward.
Who presides over the Lok Sabha and what are their key roles? The Speaker.
Yes, the Speaker, and in their absence, the Deputy Speaker. Both are chosen by the House from among its members. Conventionally, the Speaker is from the ruling party, Deputy Speaker from the opposition, but that's not a rule.
And their role?
They maintain order, conduct proceedings, decide if a bill is a money bill, their decision is final, and have a casting vote in case of a tie. The Speaker doesn't vacate office until just before the first meeting of the new Lok Sabha, ensuring continuity even if the House is dissolved. G.V. Mavalankar was the first Speaker. Interestingly, since 2019, the Lok Sabha hasn't had a Deputy Speaker.
Now, let's move to the Rajya Sabha, often called the Council of States. How is it fundamentally different from the Lok Sabha in its nature and purpose? The Rajya Sabha, Article 80, is the upper house, the second chamber, the House of Elders. It's the representative of states because its members are mainly elected indirectly by state legislative assemblies, giving states a voice at the union level and protecting federal interests.
What's its maximum strength and how are its members chosen, particularly the nominated ones?
Maximum strength is too hefty. Up to 238 are elected by state UT legislatures, and a unique feature. 12 members are nominated by the president for expertise in literature, science, arts, and social service. Think eminent artists, scientists, social workers.
Bringing expertise into Parliament.
Exactly. Current strength is 245, 225 states, 8 UTs, 12 nominated. The election is indirect, using proportional representation via single transferable vote from South Africa with open ballot voting. Seats are allotted based on state population, so it's unequal. UP has 31, Sikkim just 1. First sitting was May 13, 1952.
Is the Rajya Sabha a permanent body or can it be dissolved like the Lok Sabha? This is a crucial distinction, isn't it?
Absolutely crucial. The Rajya Sabha is a continuing chamber. It's a permanent body, not subject to dissolution.
How does that work?
To ensure continuity, 1/3 of its members retire every 2 years. New members are elected, and members serve a 6-year term. This provides stability and institutional memory, acting as a check on the Lok Sabha.
Does the Rajya Sabha have any exclusive powers, something only it can do that highlights its role as the Council of States?
Yes, it does, underscoring its federal role. Under Article 249, it can authorize Parliament to legislate on a state list subject if it's in the national interest, requires special majority, valid for 1 year, extendable. Under Article 312, it can authorize the creation of new all-India services, like IAS, IPS, again needing a special majority. It also plays a role in emergency proclamations if the Lok Sabha is dissolved.
Who presides over the Rajya Sabha?
The Vice President of India is the ex officio chairman. In their absence, a deputy chairman, elected from among RS members, presides.
The Parliament is more than just its houses. It's a dynamic arena. Let's talk about the practical workings, starting with how constituencies are adjusted after each census. delimitation.
Yes, delimitation. Article 82 mandates readjustment of constituencies after every census every 10 years. A delimitation commission redraws boundaries based on population to ensure fair representation. We've had 4 commissions, 1952, 1963, 1973, and 2002.
But haven't the seats been frozen for a while?
Yes. The 42nd Amendment, 1976, froze seats till 2000. The 84th Amendment, 2001, extended this freeze on the number of seats till 2026, based on the 1971 census population figures initially, later updated. The 87th Amendment, 2003, allowed delimitation based on the 2001 census without changing the total number of seats per state. So boundaries can change, but not the number of MPs from each state until after 2026.
How often does Parliament meet, and what are the typical sessions in a year?
Parliament meets in sessions summoned by the President, Article 85. The maximum gap between 2 sessions can't be more than 6 months. Usually there are 3 sessions: budget, Feb-May, monsoon, Jul-Sept, and winter-Nodic.
What are the different ways a parliamentary session or a house's life can end? These terms can be a bit confusing. Adjournment, prorogation.
They can be. Let's break it down. Adjournment just suspends a sitting for a specified time, hours, days, done by the presiding officer. Adjournment sine die suspends a sitting indefinitely, also by the presiding officer. Prorogation formally ends the entire session, done by the president. Dissolution ends the entire life of the Lok Sabha, leading to elections, done by the president. Rajya Sabha, being permanent, is never dissolved.
What happens if there's a deadlock between the 2 houses on a bill? Can they have a joint sitting to resolve it?
Yes, Article 108 provides for a joint sitting, summoned by the president, presided over by the Lok Sabha Speaker, is to resolve deadlocks on ordinary bills or financial bills.
No money bills or constitutional amendments.
Correct. Not possible for money bills, LS prevails.
Yeah.
Or constitutional amendment bills.
Yeah.
Need separate special majorities. We've only had 3 joint sittings so far. Dowry Prohibition Bill, 1961, not 1980. Banking Services Commission Repeal Bill, 1978, not 1977. And Prevention of Terrorism Bill, 2002. It's rare.
Is there a minimum number of members required to conduct parliamentary proceedings, a kind of minimum attendance rule?
Quorum. Yes, the quorum. Under Article 100, it's minimum 1/10 of the total members of the House. If quorum isn't met, the presiding officer must adjourn or suspend the meeting until it is. Ensures sufficient participation.
When can a member of parliament be disqualified from their seat? What are the grounds?
Article 102 lists grounds: holding an office of profit unless exempted, unsound mind declared by court, undischarged insolvent, not being a citizen or acquiring foreign citizenship, or being disqualified under any law made by Parliament.
And the anti-defection law.
That's a big one. Under the 10th schedule, added by 52nd CAA, 1985, disqualifies members for defecting from their party. Also, seats become vacant due to double membership, resignation, or absence for over 60 days without permission.
We talked about the president's assent to bills. Do they have veto powers? And if so, what are the different types?
Yes. The president has veto powers, essentially negative powers, 3 types. First, absolute veto, withholding assent, the bill ends. Used for private member bills or sometimes government bills if the cabinet resigns. Second, suspensive veto, returning a bill, not money or CA bills, for reconsideration. If repassed, president must assent. Third, pocket veto, taking no action, keeping the bill pending indefinitely, no time limit. Remember Gianni Zail Singh, famously called the Indian president's pocket deeper than American presidents.
Let's delve deeper into legislative procedures. How do different types of bills get passed, and what are the key differences between them? Ordinary, money, financial, constitutional.
Okay, quick rundown. Ordinary bill can start in either house, simple majority, joint sitting possible for deadlock. No prior presidential recommendation needed, except Art 3 bills. Money bill, Art 110 definition, Art 109 procedure. Only in Lok Sabha needs president's prior recommendation. Speaker's certificate is final. Rajya Sabha has only 14 days to return with recommendations, non-binding. No joint sitting. President must assent or withhold, cannot return. Passed by simple majority. Financial bill, Art 117, deals with money and non-money matters. Introduced like a money bill, LS, president's nod, but passed like an ordinary bill, joint sitting possible. Constitutional Amendment Bill, Art 368, amends Constitution. Can start in either house. No president's prior nod needed. Requires special majority in each house separately. Majority of total plus 23rd present and voting. No joint sitting. President must give assent. 24th CAA, 1971.
What about the special rights and immunities enjoyed by Parliament and its members? These are known as parliamentary privileges. What do they cover?
Parliamentary privileges, Article 105, are crucial for independent functioning. Key ones include freedom of speech within Parliament, immunity for anything said or voted, immunity from arrest in civil cases during sessions and 40 days before after, and exemption from jury service. They protect the institution and its members' ability to function without fear.
Let's move to the crucial aspect of financial business. How is the union budget handled in Parliament, and what are the main types of government funds?
The annual financial statement, Budget Article 112, details government receipts and expenditures. Stages in Parliament include presentation, finance minister's speech, general discussion, scrutiny by departmental committees, voting on demands for grants, Lok Sabha only, passing the appropriation bill, authorizing spending from Consolidated Fund Art 114, and passing the finance bill, tax proposals.
And the funds, consolidated, contingency.
Three main funds. Consolidated Fund of India, Art 266-400, holds all government revenues, taxes, loans. All expenditure needs Parliament's approval via Appropriation Act. Some expenditures charged, non-votable, e.g. President SC judge salaries, others made from votable NLS. Public Account of India, Art 266-2, holds money government holds in trust, like PF saving schemes. No Parliament approval needed for withdrawals as money is returned. Contingency Fund of India, Art 267, held by the President, operated by Finance Secretary for unforeseen expenses, later replenished with Parliament's approval, like an emergency stash.
And what are cut motions during budget discussions? These sound like a way for opposition to make a point.
Exactly. Used by Lok Sabha members to oppose a demand for grant, often symbolically. Three types. Disapproval of policy cut, reduced by Re1 to oppose policy. Economy cut, reduced by specific amount for economy. Token cut, reduced by Rs 100 to voice a specific grievance. They allow detailed criticism of spending proposals. Historically, first budget by R.K. Shamagam Chetty, 1947. Railway budget merged with union budget since 2017-18.
Shifting from finances to the daily flow of business in Parliament, what's the question hour and the 0 hour? Often in the news.
Key parts of the day. Question hour, first hour, 11 a.m., 12 p.m. Members ask questions, ministers answer. Keeps government accountable daily. Questions can be starred, oral answer, supplementaries allowed, unstarred, written answer, no supplementaries, or short notice, urgent oral answer. 0 hour. Follows question hour, 12 p.m., 1 p.m. An Indian innovation, informal device to raise urgent matters without prior notice. Very dynamic.
What are some other key motions that can be introduced in Parliament to raise issues or hold the government accountable?
Several important ones. Adjournment motion. Extraordinary procedure, LS only, to set aside normal business for urgent public importance discussion implies censure. Calling attention notice. Member calls minister's attention to urgent matter. Minister makes statement. Indian innovation. Rajya Sabha has motion for papers instead. Privilege motion. Moved if a member believes privilege breached by withholding distorting facts. Private member's business. Bills resolutions by non-ministers. Motion of thanks. Discusses president's address after election start of year.
Who is the pro tem speaker and what's their temporary but vital role?
Appointed by the president for the first sitting of a newly elected Lok Sabha, usually the senior-most member. President administers oath to them. Their main job is to administer the oath to the new MPs and preside until a permanent speaker is elected. Necessary because the previous speaker vacates office just before the new House meets.
And the whip. We often hear that term in political commentary. What do they do?
A whip is appointed by each political party to ensure party discipline. They ensure members attend important votes and vote according to the party line, crucial for party functioning of Parliament. Disobeying the whip can lead to disqualification under anti-defection law.
Lastly, what are parliamentary committees and which one is particularly significant for financial oversight?
Committees do the detailed work Parliament doesn't have time for. Appointed elected by the House or nominated by the presiding officer. Two main types. Standing committees, permanent, subject-specific, like departmental standing committees, 24 of them, examining bills, grants, and ad hoc committees, temporary for specific tasks like inquiries.
And for financial oversight.
The Public Accounts Committee, pay, is key. First set up 1921. 22 members, 15 LS, 7 RS, elected annually. Minister cannot be a member. Examines the CAG's audit reports on government spending. The CAG is often called the PAG's friend, philosopher, and guide. Crucial for financial accountability.
We've covered the intricate workings of the union government. Now let's move to governance at the state level, starting with the governor. What's their unique role in a state's political system?
The governor is the chief executive head of the state, but like the president, they're the nominal head, de jure. Most powers exercised on advice of the State Council of Ministers, headed by CM. However, a key difference. The governor also acts as an agent of the central government, a vital link.
Agent of the center. That sounds potentially controversial.
It often is. It's meant to ensure the state government functions constitutionally and follows central directives, but it can lead to friction.
How is a governor appointed, and for how long do they typically serve?
Appointed by the President, Article 155, not elected. The Seventh Amendment, 1956, allows one person to be governor for 2 or more states. They hold office during the pleasure of the President, meaning they can be removed at any time, but the normal term is 5 years. They can resign to the President.
What are the basic qualifications to become a governor, and are there any unique conditions for holding this office?
Qualifications, Article 157, citizen of India, minimum 35 years old. Conditions, Article 158, cannot be an MP or MLA, must resign if appointed, cannot hold office of profit, entitled to official residence, salary, etc., which can't be reduced during their term.
Who administers the oath of office to the governor?
The Chief Justice of the concerned High Court or the senior-most judge available, Article 159.
We discussed the president's expansive pardoning power. Does the governor have similar powers, and are there any key differences?
Yes, the governor has pardoning power under Article 161 for offenses against state laws. Pardon, reprieve, respite, remission, commute. But 2 crucial differences. The governor cannot pardon death sentences, only president can, and cannot pardon sentences by martial courts. Highlights federal structure limits.
What about the governor's executive, legislative, and financial powers? How do these manifest at the state level?
Executive. Appoint CM and other ministers, on CM's advice, Advocate General, state PSC chairman members, district court judges. Legislative. Summons prorogues state legislature, dissolves Vidhan Sabha, usually on COM advice, inaugurates legislature, bills need governor's assent, can return non-money bills, crucially, can reserve certain bills for the president's consideration, can promulgate ordinances, Art 213. Financial. Money bills need prior recommendation, causes state budget to be laid, constitutes state finance commission, can make advances from state contingency fund.
Do governors have any specific discretionary powers where they don't necessarily have to act on the advice of the Council of Ministers? This seems to be where the agent of center role might come in.
Yes, this is significant. Discretionary powers include appointing CM when no party has clear majority, reporting to President on constitutional breakdown, recommending President's rule, Art 356, reserving bills for President's consideration. These are where the governor acts on their own judgment and where controversies often arise.
So, on bills, the governor also has a veto power, similar to the president. What are the options under Article 200?
Yes, when a state legislature passes a bill, the governor, Article 200, can 1. Give assent, 2. Withhold assent, 3. Return the bill, if not money bill, for reconsideration, 4. Crucially, reserve the bill for the president's consideration. If reserved, the president then has the final say, including an absolute veto.
From the governor, let's move to the real executive power in the states, the chief minister and the council of ministers. How does that structure operate, mirroring the union setup?
Very similar to the union. The chief minister is the real executive authority, appointed by the governor. Other ministers appointed by governor on CM's advice. They hold office during governor's pleasure. Effectively, CM's confidence and assembly majority.
And collective responsibility.
Yes, the State Council of Ministers is collectively responsible to the Legislative Assembly. Vidhan Sabha. The CM must furnish information to the governor. A subtle difference. Governor's advice from command is not binding in all matters, especially regarding discretionary powers.
Let's discuss the state legislature. Do all states in India have 2 houses, like the Union Parliament? Bicameralism?
No, not all. Article 168 allows for a legislature with governor plus 1 or 2 houses. Most states are unicameral, only legislative assembly. Only 6 states currently have 2 houses bicameral. Andhra Pradesh, Bihar, Telangana, Maharashtra, Karnataka, Uttar Pradesh. They have both a legislative assembly, Vidhan Sabha, and a legislative council, Vidhan Parishad.
What are the key features of the legislative assembly, the lower house at the state level?
The Vidhan Sabha is the lower directly elected house. Strength varies, max 500, min 60. Some small states have exceptions, e.g. Sikkim, Goa in 30. Duration is 5 years, unless dissolved earlier. Can be extended during national emergency. Has a speaker and deputy speaker chosen by the Assembly, Art 178. Min age for members is 25.
And the Legislative Council, the upper house or Vidhan Parishad, how are they formed or even abolished, as they don't exist in all states? That sounds flexible.
Very flexible. The power lies with Parliament, Article 169. Parliament can create or abolish a legislative council if the state's legislative assembly passes a resolution by a special majority. Majority of total membership plus 23rd present and voting. Importantly, this act of Parliament is passed by a simple majority and is not considered a constitutional amendment under Art 368. Gives states the choice.
Is the Legislative Council a permanent body like the Rajya Sabha?
Yes. It's a continuing chamber, not subject to dissolution. One-third members retire every 2 years. Members serve 6-year terms. Has a chairman and deputy chairman chosen by the council, Art 182. Minimum age for members is 30.
Finally, do ministers and the Advocate General have the same rights to participate in the state legislature as their counterparts at the union level?
Yes, very similar. Article 177 gives ministers and the state Advocate General the right to speak, take part in proceedings of either house, if bicameral. But they cannot vote unless they're elected members.
We've thoroughly examined the executive and legislative branches. Now let's turn to the third and arguably most crucial pillar, the judiciary, starting with the apex court, the Supreme Court of India. What's its fundamental role?
The Supreme Court, Part V, Articles 124-147, is the highest judicial forum, the final court of appeal. It's a federal court settling union state or interstate disputes. Most importantly, it's the ultimate guardian and interpreter of the Constitution. It replaced the old federal court and Privy Council appeals. First sitting was January 28, 1950.
How is the Supreme Court composed, and has its strength changed over time?
Originally, Article 124 provided for 1 Chief Justice plus 7 other judges, 8 total. But Parliament was empowered to increase this. It has done so multiple times. Currently, it's 1 CJI plus 33 other judges, totaling 34, reflecting the massive workload.
How are these judges, particularly the Chief Justice, appointed? We touched on this with the collegium.
Yes. All appointed by the President. CJI appointed after consultation with SCHC judges as deemed necessary. Other judges appointed after consulting the CJI and other judges. The CJI's recommendation is now mandatory due to the collegian system evolution.
Remind us about the collegian system's origin again, not in the Constitution itself.
Correct. It evolved through the judges' cases. First judges' case, 1982. CJI's view not binding. Second judges' case, 1993. Introduced collegium, consultation means concurrence, CJI plus 2 senior judges opinion binding. Third judge's case, 1998, expanded collegium to CJI plus 4 senior most judges. Fourth judge's case, 2015, struck down the 99th CAA, which created the NJAC with government involvement, reinstating the collegium, emphasizes judicial primacy in appointments.
What are the qualifications to become a Supreme Court judge, and what's their tenure?
Qualifications, Article 124, citizen of India, must be HC judge for 5+ years, or HC advocate for 10+ years, or a distinguished jurist in president's opinion, no minimum age, tenure, serve until 65 years of age, no fixed term length, can resign to president.
How are Supreme Court judges removed? Must be tough.
Extremely. Removal, Article 124, is by president, only after a resolution passed by Parliament with a special majority in both houses, majority of total plus 23rd president voting, on grounds of proved misbehavior or incapacity. Procedure governed by Judges Inquiry Act, 1968. No SC judge has ever been impeached successfully.
Any notable firsts in the Supreme Court's history?
Justice Fatima Bavey, 1987, was the first female judge. Still no female Chief Justice yet. First CJI was H.J. Kania, 1950-1951.
What are the different types of jurisdiction the Supreme Court exercises? Original, appellate.
Several key types. Original, Article 131, exclusive for union state or interstate disputes. Appellate, Articles 132-136. Highest appeal court, constitutional, civil, criminal matters. Can grant special leave to appeal, can transfer cases. Advisory, Article 143. President can consult SC on law fact. Advice not binding on president, but mandatory for court on pre-constitutional matters. Writ, Article 32, for enforcing fundamental rights.
Can the Supreme Court review its own judgments, or are its decisions always final?
While final, Article 137 allows the SC to review its own judgments or orders. Allows self-correction. Article 141 says law declared by SC is binding on all courts. Article 142 gives power to pass orders for complete justice enforceable throughout India, like in Bhopal gas tragedy.
This concept of judicial activism often comes up. What does that mean in the Indian context? Is it the court overstepping?
It refers to the judiciary taking a more proactive role, sometimes interpreting law broadly, intervening in governance, or setting new principles to ensure justice or protect rights, especially when legislatures or executives seem inactive. It's debated, but seen by many as vital for upholding the Constitution. SC's ancillary powers, Art 140, also help.
So if the Supreme Court is the apex, what about the high courts at the state level? They seem to be the primary judicial bodies for most citizens.
You're right. High courts are at the apex of state judiciary. Article 214 provides for one per state, but the 7th Amendment, 1956, allows Parliament to establish common HCs for multiple states' UTs. There are 25 HCs currently.
Can you give us some examples of these common high courts?
Sure. Bombay HC, Maharashtra, Goa, Dadra and Nagar Haveli, Daman and Diu, Guwahati HC, Assam, Nagaland, Mizoram, Arunachal Pradesh, Punjab and Haryana HC, Punjab, Haryana, Chandigarh, Calcutta HC, West Bengal, Andaman and Nicobar. Delhi and Jammu and Kashmir are UTs with their own HCs.
How are high court judges appointed and what are their qualifications compared to the Supreme Court?
Appointed by President, Article 217, CJ of HC. President consults CJI and Governor other HC judges. President consults CJI, Governor, and CJ of that HC. Qualifications. Citizen. Held judicial office for 10 years or advocate of HC for 10 years. No distinguished jurist category like SC. No minimum age.
What's their tenure and how are they removed?
Tenure. Until 62 years of age. SC is 65. Resigned to President. Removal is the same process as SC judges, by President on Parliament's recommendation. Vacates office if appointed to SC or transferred. Salaries from State Consolidated Fund. Pensions from India's Consolidated Fund.
We discussed the writ jurisdiction for the Supreme Court. How does that compare for the high courts? Is it equally powerful?
The High Court's writ jurisdiction, Article 226, is actually wider. While SC, Art 32, issues writs only for fundamental rights, AGCs can issue them for FRs and for any other purpose, ordinary legal rights. Gives AGCs broader scope.
What are the other types of jurisdiction high courts have beyond writs, especially their supervisory role over lower courts?
They have original jurisdiction, for example, election petitions. Extensive appellate jurisdiction over subordinate courts, civil, criminal, revisory jurisdiction, checking legality of lower court orders, and significantly supervisory jurisdiction, Article 227, over all courts and tribunals within their territory, except military. This administrative oversight is crucial for the entire justice system's functioning.
Let's turn to critical aspect, the emergency provisions, Part 8, Articles 352, 360, adapted from Germany's Weimar Constitution, right? What are the three types?
Yes, inspired by Weimar. They grant extraordinary powers for crises. Three types. National emergency, Article 352, for threats to India's security. President's rule, Article 356, for failure of state constitutional machinery. And financial emergency, Article 360, for threats to financial stability.
Let's break down national emergency first. What are the grounds and what's the role of the cabinet? Has this changed?
Grounds. War, external aggression, or armed rebellion. The term internal disturbance was replaced by armed rebellion via the 44th Amendment, 1978, to make it stricter, less open to misuse. The President proclaims it, but only on the written advice of the Cabinet, also 44th Amendment safeguard. Can be for whole country or a part.
How is a national emergency approved by Parliament and for how long does it last?
Must be approved by both houses within 1 month by a special majority. Once approved, lasts 6 months. Can be extended indefinitely with parliamentary approval, special majority every 6 months. Can be revoked by President any time. If Lok Sabha disapproves continuance, simple majority, President must revoke.
What's the impact of a national emergency on fundamental rights? Is everything suspended?
This is critical. While many FRs can be suspended, Articles 20 and 21, life, liberty, conviction protection, cannot be suspended. A vital safeguard. Also, the 44th Amendment restored judicial review of any proclamations.
Has India seen national emergencies proclaimed before?
Yes, 3 times. 1962, India-China War, Nehru. 1971, India-Pakistan War, Indira Gandhi. And controversially, 1975, internal disturbance, Indira Gandhi Fakhruddin Ali Ahmed. The 1975 one is often heavily criticized.
Next, President's rule or state emergency under Article 356. What are its grounds and how does it relate to the governor's report?
Grounds. President satisfied, based on governor's report or otherwise, that state government cannot function according to Constitution. Basically, constitutional breakdown. Also triggered if a state fails to comply with Senator's directions, Art 365. Article 355, Union's duty to protect states, underlies this.
How is President's rule approved by Parliament and what's its maximum duration?
Parliament must approve within 2 months by simple majority. Lasts 6 months initially, maximum duration is 3 years, with repeated 6-month approvals. But beyond 1 year needs specific conditions. NE in force, or EC says elections impossible, prevents indefinite central rule.
What are the effects of President's rule on a state and is it subject to judicial review?
Effects. State Council of Ministers dismissed, state legislature suspended or dissolved, Center takes over administration. No effect on citizens' fundamental rights, though. Crucially, it is subject to judicial review, thanks to the S.R. Bommai v. Union of India, 1994 case. Limited arbitrary use. First imposed in Punjab, 1951. Max times in Manipur, 10, and UP 9.
Finally, financial emergency under Article 360. What are its grounds and what would be its potential effects?
Grounds. President satisfied financial stability or credit of India or any part is threatened. Approval. Parliament within 2 months by simple majority. Duration. Once approved, continues indefinitely until revoked. No max period. Effects. President can direct states on financial propriety, reduce salaries, including SCHC judges, reserve state money bills. Remarkably, financial emergency has never been imposed in India.
The Indian Constitution is often called a living document, having undergone over 100 amendments. This adaptability is key, isn't it? How does that process work under Article 368?
Absolutely. Part XX, Article 368, details the amendment power and procedure. As Casey Ware said, it strikes a good balance between rigidity and flexibility. It allows change, but protects core principles.
How is a constitutional amendment bill introduced and passed?
Introduced in either House of Parliament, not state legislatures,
Yeah.
by a minister or private member, does not need president's prior permission, must be passed by both houses separately by a special majority.
Remind us of that special majority again.
Majority of the total membership of the House, A and D, a majority of 2/3 of members present and voting. High threshold, no provision for joint sitting if houses disagree. Both must pass it independently.
And the president's role.
President must give assent, 24th CAA, 1971. No veto power here.
You mentioned different types of majorities earlier. How do they apply to amendments?
3 ways the Constitution can be amended. 1, simple majority, like ordinary laws, for things like forming new states, altering boundaries, abolishing legislative councils. 2, special majority of Parliament, Art 368 standard, for most provisions, including fundamental rights, DPSPs. 3, special majority of Parliament plus ratification by half the states by simple majority. For provisions affecting federal structure, e.g. election of president, powers of SCHC, representation of states in Parliament, the lists in 7th Schedule, Art 368 itself. Ensure states agree on changes affecting them.
The concept of the basic structure is fundamental here. What is it and when was this doctrine established?
The basic structure doctrine is a judicial innovation limiting Parliament's amendment power, famously established by Kesavananda Haradi case, 1973. SC ruled Parliament can amend any part, but cannot alter the basic structure.
What counts as basic structure?
Things like democracy, secularism, federalism, judicial review, rule of law, parliamentary system, free and fair elections, the core identity. Reaffirmed by I.R. Cole case, 2007, saying even laws in 9th Schedule can be reviewed if they violate basic structure. Judiciary is final guardian.
Let's highlight some of the most impactful amendments that have shaped India over the decades, maybe just a few key ones.
Okay, some big ones. First, 1951, added 9th Schedule, land reforms. 7th, 1956, reorganized states, allowed common HCs. 24th, 1971, affirmed Parliament's amendment power, made President's assent mandatory. 42nd, 1976, mini-constitution. Added socialist, secular integrity to preamble, fundamental duties, new DPSPs, tried limiting judicial review. 44th, 1978, reversed some 42nd changes. UD armed rebellion, deleted right to property FR, restored judicial review of NE. 52nd, 1985, added anti-defection law. 10th Schedule. 61st, 1989, lowered voting age to 18. 73rd and 74th, 1992, constitutionalized panchayats and municipalities, Part 9 IXA. 86th, 2002, made education a fundamental right. Art 21A, added 11th duty. 91st, intercheat capped minister size at 15%. 101st, 2017, introduced GST. 106th, 2023, reserved 13 seats for women in LSLAs. These really show the Constitution evolving.
Now that we've covered the grand framework, let's zoom in on power at the grassroots, Panchayati Raj and municipalities. How did these vital local bodies finally get constitutional recognition? It took a while, didn't it?
It did. The journey stems from Gandhi's vision of Gram Swaj. Several committees pushed for it. Balwant Rai Mehta Committee, 1957, recommended the 3-tier system. Later, L.M. Singhvi Committee, 1986, strongly urged constitutional status for PRIs for effectiveness and viability.
And this finally led to the landmark 73rd Amendment.
Yes, the 73rd Amendment Act, 1992, was the watershed moment. Constitutionalized Panchayati Raj, added Part 9, Arts 243, 243.0, and the 11th Schedule, 29 functional items for panchayats like agriculture, health, education. Enforced April 24, 1993, now celebrated as Panchayati Raj Divas.
What are the key provisions introduced by this amendment that truly brought power to the villages?
Key provisions. Mandates 3-tier system. Village, intermediate, district. Those states' 20 lakh population can skip intermediate. Constitutional recognition for Gram Sabha, all voters in village. Direct election for all seats. Reservations for SC/SSTs, proportional, and 13 for women, members and chairpersons, at all levels. Fixed 5-year tenure, elections within 6 months it dissolved. Independent State Election Commission conducts polls. State Finance Commission, Art 243I, reviews finances, recommends grants taxes, empowers states to let panchayats levy taxes.
What about special provisions for scheduled tribal areas? PISA.
Yes, the PISA Act 1996, Panchayat Extension to Scheduled Areas, extends Part 9X provisions to scheduled areas, but with modifications to respect tribal traditions, customary laws, and community resource rights. However, Article 243M excludes Nagaland, Meghalaya, Mizoram, unique governance traditions, and most UTs except Delhi from direct application.
And for urban local governance, mirroring the panchayats.
Urban local bodies, municipalities, were constitutionalized shortly after by the 74th Amendment Act, 1992. Added Part IXA, Arts 243P, 243ZG, and the 12th Schedule, 18 functional items like urban planning, roads, water supply, also have a fixed 5-year tenure. Together, the 73rd and 74th Amendments represent a massive decentralization effort.
Beyond the main branches, India relies on several independent bodies, constitutional and non-constitutional, as crucial watchdogs. Let's start with the Election Commission of India, its role.
The ECI, Article 324-329, Part XC, is a fundamental, permanent, independent constitutional body. Ensures free, fair elections for Parliament, state legislatures, President, VP, originally single-membered, now multi-membered, CEC plus 2 ECs, since 61st Amendment lowered voting age, CEC appointed by President, 6 years, 65 years tenure, salary same as SE judge, not involved in panchayat municipality elections, state ECs handle those. Powers, delimitation, electoral rolls, schedules, party recognition symbols, code of conduct, advise on disqualifications, cancel polls. First, CZC's commerce.
What about recruitment to public services, UPSC, SPSC?
UPSC, Union Public Service Commission, Article 353, Part 14. Independent constitutional body, chairman plus members. President's assigned number. Term 6 years, 65 years. Recruits for all Indian Central Services. Watchdog of merit system. Removed by President on specific grounds via SC inquiry. Similarly, each state has an SPSC, State Public Service Commission, independent constitutional, term 6 years, 62 years, recruits for state services, removed by President via SE inquiry, both crucial for impartial bureaucracy.
And financial distribution between center and states. Finance Commission.
Yes, the Finance Commission, Article 280, quasi-judicial body, chairman plus 4 members, appointed every 5 years by President, recommends sharing of taxes between center and states and grants and aid, recommendations not strictly binding but usually accepted. Vital for fiscal federalism. First FC, 1951, K.C. Niaji.
Who audits government accounts? The CAG?
The Controller and Auditor General of India, SEC, Article 148-151. Head of Indian Audit and Accounts Depth, independent, single-membered, appointed by President, 6 years, 65 years, removed like SC judge. Audits all expenditure from consolidated funds, union and state, contingency funds, public accounts, guardian of public purse. Ambedkar called it most important officer. Submits reports to President Governor, laid before Parliament legislature. Acts as guide to PAC.
Legal advice for the government, Attorney General.
Attorney General of India, AGI, Article 76. Highest law officer, appointed by President. Qualified to be SC judge. Term not fixed, pleasure of President. Advises GOI, right to speak, attend Parliament, no vote. Enjoys MP privileges. First AGI, MC Salvad. Similarly, states have Advocate General, Article 165, appointed by Governor.
What about commissions for specific social groups like SCs, STs, BCs?
Constitutional bodies exist for them. National Commission for SCs, Art 338, STs, Art 338A, BCs, Art 338B, multi-member, appointed by President. NCSE and CST bifurcated by 89th CAA 2003. NCBC got constitutional status via 1 and 2nd CAA 2018. Also, Special Officer for Linguistic Minorities, Art 350B, constitutional status via 7th CAA 1956. Appointed by President to promote minority language rights, a specific primary education in mother tongue, Art 350A.
Beyond these constitutional entities, are there other significant non-constitutional bodies playing major roles, like NITI Aayog?
Yes, several crucial ones operate outside direct constitutional framework. NITI Aayog, executive body, created January 1, 2015, replaced Planning Commission. PM is chairman, acts as policy think tank. Fosters cooperative federalism. Central Vigilance Commission, CVC, deals with corruption. Eston, 1964, exec resolution. Statutory status, 2003. Recommended by Santhanam Committee. Central Bureau of Investigation, CBI, investigating agency. Set up 1963, exec resolution. Powers from Delhi Police Establishment Act, 1946. Law Commission. Executive body, suggests legal reforms. First post-independence, 1955. Setalvad, Lokpal and Lokayukta. Anti-corruption ombudsman.
Statutory body, Lokpal and Lokayukta Act 2013. Lokpal Center, Lokayukta State, First Lokpal. Pinaki Chandra Ghose, 2019. The State Human Rights Commission, SHRC. Non-Constitutional Statutory Protection of Human Rights Act, 1993. Inquires into state-level human rights violations.
That's an incredible overview. To round it off, what are some final overarching concepts that help us understand India's unique constitutional character? Quasi-federal, all India services.
Yes, two key terms capture it well. Quasi-federal, term by K.C. Ware. It's federal, but with strong centralizing features, balancing autonomy and unity. All India services, IAS, IPS, IFOs, Art 312, common to union states, recruited by center but serve in states, promoting national integration and uniform standards. Also, the evolution of official languages, Part 7/8 schedule, is fascinating. Started with 14, now 22 recognized languages through amendments, plus several languages given classical language status, Tamil, Sanskrit, Telugu, Kannada, Malayalam, Odia, recognizing their ancient heritage, shows commitment to linguistic diversity within a unified framework.
We've truly embarked on a comprehensive deep dive today, from the historical foundations and intricate crafting of the Indian Constitution, drawing deep wells of inspiration from around the world to how it's adapted over time.
Right. We traverse the fundamental rights that powerfully shield every citizen, the guiding principles that shape state policy, and the crucial duties that bind us all to the nation.
We've explored the distinct roles of the president and the real executive power wielded by the prime minister. We delve into the intricacies of the parliament and state legislatures, understanding how laws are truly made and accountability is ensured.
We've even peeled back the layers of the independent judiciary, understood the vital checks and balances that emergency provisions provide, and witnessed how constitutional amendments keep this living document robust and relevant. And finally, we touched upon grassroots governance through panchayats and municipalities, and those critical constitutional and non-constitutional bodies acting as watchdogs.
So what does this all mean for you, the listener? Understanding India's political system isn't just about memorizing facts and figures. It's about appreciating the living, breathing framework that governs over 1 billion lives.
Exactly. It's about recognizing the incredible foresight of its framers and the continuous evolution it undergoes. That remarkable balance between rigidity and flexibility, the emphasis on building a welfare state, and the elaborate mechanisms for citizen participation and accountability. They're all intricately designed to serve its incredibly diverse populace.
Consider this provocative thought. India's constitution, though partly rigid and partly flexible, has shown remarkable resilience and adaptability over nearly 75 years, undergoing over 100 amendments. What unique challenges do you think this blend of rigidity and flexibility presents for a country that is constantly evolving, navigating new social and economic realities?
And how might understanding this historical and ongoing adaptation inform our perspective on other evolving democracies around the world? It's definitely a powerful lesson in constitutional endurance and adaptation, something to really mull over.
This is truly just the beginning of understanding the dynamic nature of governance in the world's largest democracy. We hope this deep dive has sparked your curiosity and provided you with valuable, concise insights. Join us next time on the deep dive for more fascinating explorations.